Well, good morning, Jaginder Rana here. The topic for our discussion today is non-disclosure of other existing policies. Non-disclosure of other existing policies. The Supreme Court of India, while deciding an insurance-related claim, observed that insurance is a contract of utmost good faith, and it is an insured's duty to disclose all material facts. Non-disclosure of such fact may result in repudiation of the claim. However, the materiality of a certain fact is decided on a case-to-case basis. So an insurance is a contract wherein fights. It is the duty of the applicant to disclose all facts which may weigh with a prudent insurer in assuming the risk proposed. So these facts are considered material to the contract of insurance, and at its non-disclosure may result in the repudiation of the claim. The materiality of a certain fact is to be determined on a case-to-case basis. So in the present case, the appellant's father had taken an insurance policy from the respondent, that is Exide Life Insurance Company, for rupees 25 lakhs. Now, following his father's death, the present appellant submitted a claim for payment of benefits under the policy. However, the claim was repudiated on the ground that there was material suppression by the father of the appellant, who disclosed only one policy taken by him from Aviva Life Insurance, whereas concealed other life insurance policies. So since the appellant's claim was dismissed by the state and the National Consumer Commission, he approached the Apex Court. Now at the outset, the court noted that the policy disclosed by the appellant was for rupees 40 lakhs. This amount was significantly more than the policies not disclosed, which were of an aggregate amount of rupees 2.3 lakhs. So the court also relied on several cases, including its decision, that is Reliance Life Insurance Company Limited and another versus Rekhaben Naresh Bhai Rathod, whereby the insurer was held to be entitled to repudiate the insurance claim because of the appellant's failure to disclose his previous insurance policies. So the primary consideration that was weighed was the disclosure could have allowed the insurer to question why the insured had, in a short span of time, obtained two different life insurance policies. However, with respect to the present case, the court observed that the insured had already made a substantial disclosure, while the other policies were of an inconsequential sum. So the case at hand involves a slightly different consideration. The father of the appellant had disclosed one other life insurance policy availed by him at the time of filing the proposal form, but failed to disclose other similar policies. So while the aforementioned judgment relates to a complete failure to disclose in the peculiar circumstances of two policies being availed of in a short span of time, the present case stands on a different footing of substantial disclosure, which would be sufficient for a prudent insurer to determine the risk assumed. So taking a cue from this, the court said that the present non-disclosure would not influence the decision of a prudent insurer to issue the policy proposed. Now, the policy in question is not a medical policy. It's a life insurance cover, and the death of the deceased has taken place on account of an accident. So, accordingly, failure to mention about other policies does not amount to a material fact in relation to the policy availed, and consequently, the claim could not have been repudiated by the respondent company. Thus, even though the insurer was aware that there was another policy for a higher sum assured, the insurer was confident that the insured had the capacity to pay the premium in respect of the present policy. So the respondent insurer decided to issue a policy to the father of the appellant. Herein, even though it was aware that there was another policy for a higher sum assured, which was taken by the insured from the Aviva. Thus, the insurer was also aware of the fact that the insured had capability and capacity to pay the premium for the policy obtained from Aviva, and was confident that the insured had the capacity to pay premium in respect of the policy which was issued to the insured by the respondent insurer for a sum lesser assured being rupees 25 lakh only. So in view of this, court found that the repudiation was improper, and it directed to release all benefits under the policy along with an interest of 9% per annum to the appellant as an upshot. The appeal was allowed and the impugned order was set aside. So this is a simple case where it is believed by the Apex Court of India that even if the policy, another policy taken by the insured on his life, or even if there is any other existing policy, if it is not disclosed, it doesn't mean the insurer has got a right to repudiate the claim. Because insurance is a contract of a bona fides. Of course, it is the duty of the applicant to disclose all facts, rather all material facts, which may weigh with a prudent insurer in assuming the risk proposed. So this fact was concealed, this was not disclosed, and because of this non-disclosure, the insurer has got no right to repudiate the claim, because this is neither affecting the premium of the insurance company nor affecting the risk of the insured. So it is immaterial whether he is disclosing or not disclosing. It is immaterial whether he has got 1 life policy or 3 life policy. In fact, once the premium is paid for the life insurance policy by the insured, it is the duty of the insurance company to pay the claim in case of the death of the insured or in case of the maturity of the policy. So insurer has got no right to seize the benefits just because the insured has not disclosed any other existing life insurance policy on his life, because the material fact is that this policy is issued by the insurer after disclosing all other related factors, except that the other policies were not disclosed. So the court also relied on the several cases and considered, but the primary consideration that was weighed was the disclosure could have allowed the insurer to question why the insured had in a short span of time obtained 2 different life insurance policies. So with respect to the present case, the court observed that the insured had already made a substantial disclosure, while the other policies were of an inconsequential sum. So this case involves a slightly different consideration. and hence it is payable. Thank you.